Well, good morning, everybody, and welcome to this edition of John's Rants. My name is John Giardinelli. I am the association's attorney. I am with the law firm of the Tyler Law, LLP, and we're going to talk today about a couple of issues. I want to go deep on one topic. We did a legal panel not too long ago, and we got a lot of questions and a lot of miscommunication on the issue of what happens when the property that you're either listing or showing has a full security system both in and out. How do you deal with that? And so I want to talk about that for a few minutes today, give you a little bit of guidance. It's a tough law. So again, you've got a house, you're listing it, or your clients want to take a look at it, and what can we do if there is a full-on security system? Remember, California has a state law. It's Penal Code Section 632. California is only one of 11 states in the nation that requires that both parties give consent. It's actually a two-party consent procedure. And this means that you cannot record either via audio or via video certain confidential conversations. And if you do, it is going to cost you some money potentially, or it could even lead to criminal charges, although that's rare in the real estate world. We all have what is commonly referred to somewhat of a dwindling right, and it is the right to privacy. We all have expectations that certain things are not going to be recorded, are not going to be videoed, and that the legal term is an expectation of privacy. And so if someone has an expectation of privacy, that expectation needs to be protected. This is especially true in telephone calls, where there needs to be a system where the person gives consent to the recordation of the telephone call, but also has to be reminded through a certain beep system. Well, again, I want to remind you that in California, we have a thing called the Invasion of Privacy Act. And in the Invasion of Privacy Act, there are both civil and criminal monetary penalties for breaching those rights of privacy. And there are very few exceptions unless you can clearly establish that you are gathering evidence of a crime. You're probably not going to be able to show an exception. You also have the Code of Ethics and the MLS rules. Under Article 1, Standard of Practice 1.16, and this is for listing agents. The seller and the owner will dictate, so long as it's legal, how their property is to be shown. Is it going to be a lockbox? Is it going to be through open houses? Is it going to be by appointment only? They will tell the listing agent how they're to show property. A little quick caveat, everybody has to be treated the same. You can get into some real fair housing issues if you don't treat everybody the same. So that is the MLS rule for listing agents. The rule for buyer's agents is a little bit different. It's found in Article 3, which is the cooperation article, and it's Standard of Practice 3-9. Took a little bit of a modification this year, but it basically says that the buyer and the buyer's agent must comply with however the seller wants the property to be shown, so long as it doesn't violate any laws. Again, in open houses, it's generally easier, but I had a case that had they had audio, an audio security system and a video security system, the broker would have been in great shape. It was a large house. A couple came up in an Escalade, acted like they owned the world. They were con artists, and while the wife kept the agent who was sitting the open house by herself busy, the agent allowed the alleged husband to go around the house. He wrote down a bunch of information in the husband's office regarding credit cards and all of that, and in essence stole the identity of the sellers. Now, that's a rare occurrence, but things like that do happen. So what can we do about it? Well, number one, you can post a sign. If you post a sign indicating that the property, for example, I've seen signs in front of my house that the property is monitored by XYZ security system, both audio and visually. You can do that, but you have to put that sign in a prominent place so it's absolutely clear that you cannot get into the house without viewing that sign. Of course, you can turn it off. And again, that solves that problem, because again, remember, with an expectation of privacy, if I'm talking to my realtor and we're pointing out some things that there's problems, or maybe we're talking about how to create an offer, well, there's an expectation that the seller and or the listing agent is not listening in. And so you can either do that. You can put a warning in the multiple listing service. Now, I know you can put one in the private remarks, which only goes to the buyer's agent. It doesn't necessarily cover the client themselves, but you can, and I will check and report back next month. I have an appointment with the attorney for the MLS. I believe you can also put those remarks in the public section, but I want to double check. One thing you can never do, and I know this sounds weird, but you can never, ever put a camera in a bathroom. I know that sounds self-evident, but people do that, and you cannot ever do that. And there's some emerging rules now for doorbells. So the long and the short of it is, you can have a system, it can be in operation, but you can't do it secretively. You have to take multiple steps to make sure that people realize that they are being recorded, and that by entering that house, they're giving implied consent. If you fail to do that, or you do not disable the system temporarily, you could get yourself in a whole lot of trouble. Another topic that's real hot right now is insurance. A couple of things I wanted to talk to you about today. As you've probably heard, both State Farm and Allstate have indicated that they're not going to be writing homeowners insurance within certain parameters in California. And people are, I just want to let you know that as of June 27th, which is today, people are working on that, trying to come up with solutions. Obviously, there are other insurance companies that are writing up the insurance policies, but as of now, both State Farm and Allstate have made those announcements. I think it's just the first of what could be some real insurance problems in California. And again, without being political, the fact is California is not only a very litigious state, but liability is not that difficult in certain circumstances to establish. We've seen that litigation in the last year has gone up 9%, and mediations have gone up 29%. So we're definitely seeing more claims. And with more claims for the insurance companies, that means more cost that they will be passing on to the consumer. So I believe that in addition to property insurance, homeowners insurance, you're going to see some real issues in the arena of E&O coverage. There's been a couple of insurance cases. There is a case that was decided. The insurance company refused to cover the landlord in a claim that was being made by the tenant that the property was not inhabitable. And the argument by the tenants group was that the landlord was trying to force people to leave the property by making the property uninhabitable. In other words, some indication of intentional bad conduct, which is not always covered. But the way this was pled by the plaintiff's attorney, the insurance company was ordered to cover not only the cost of defense, but any damages other than intentional damages that might be caused. So insurance is on the front burner, and we're going to be probably talking about it a lot more as we move down the road. I was talking to the MLS attorney as far as the violations that are going on down there. No photo is number one. So you got to have a photo. And if you don't have a photo, then you got to have a checkbook so you can write a check for the fine. You got to have a photo. And I believe it's within 2 or 3 days after you place the listing in the MLS that a photo of the property has to be included. And photography is actually one of 3 of the top 5 violations, because in addition to no photo, people are putting in photos and are branding these photos. In other words, they're putting a picture in with a copy of their for sale sign so that buyers can contact them directly, which goes directly against the purpose of the multiple listing service. And then there is also a rule that if you put any information in the MLS, particularly a photo that has been copyrighted and does not belong to you, that is a very extensive fine. And Zillow was just hit with a massive lawsuit and is having to pay some very significant damages because they allegedly used photographs that were copyrighted, and as a result are paying some significant damages. A couple of other things before I close it out for the day. There is now many of you, and you're going to have to check your own records to find out when you are required to take and renew your license. And when you do that, it's a good possibility you're going to have to take a class on implied bias. Now, Amanda, one of the attorneys at C.A.R., wrote up that program. She created it for the Department of Real Estate. You can take that class at C.A.R. And so if you're required to take implied bias training, take a look at the class at C.A.R. It is ready to go. I asked Lori Smith, who is the professional standards manager, what's going on in her world. Number one, and in no particular order, but and we see this come back every now and then. The Craigslist rental frauds seem to be rearing their ugly heads, where Craigslist finds a listing in the MLS and then lists it on Craigslist as if it's their listing in order to get some money on a property they don't have a right to rent out. We're seeing buyer's agents hand over keys to buyers before escrow closes. Do not do that. Do not do that. Make sure that escrow has closed and possession has been transferred before you turn over keys. We're seeing incorrect neighborhood market reports being disseminated, and the brokers are failing to give credit to the listing agent on active and pending listings. And then our favorite are teams. According to Lori, in her world, we're seeing two main issues. One is that the properties are not being advertised properly, and that the actual brokerage, not the team, but the brokerage name is prominently displayed. All right, today, June 27th, which is when I'm recording this, the new forms are coming out, and the revised forms. There are, I believe, 4 new forms and 60 revised forms. Take a look at our newsletter that is posted to your association's website. We had a lot of talk on a panel that we recently did for Fair Housing about the new, it's not new, they're renaming the pet addendum, and they're calling it the Animal Terms and Conditions Addendum. And they're allowing both service and pet animal and companion animals to be included. So that's a great new form. Take a look at our law firm's information as a service to the associations. We do newsletters, and we've done a newsletter on many of the new forms. So keep that in mind. Well, that's it for today. I think that we'll stop there. If you have a topic you want me to cover and go deep on in one of these ramps, email me, jvg@tylerlawllp.com. So it's jvg@tylerlawllp.com. Or you can ask Lori and she'll give you my email address. Or you can just send your concerns to Lori, because she's great about forwarding those things to me. And we're always looking for new and exciting topics. I'll be recording another one of these in a couple of weeks. And so if you've got something that's just driving you crazy, send us an email and I'll do my very best to cover it in an upcoming rant.